Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, we are back in Calloway County with injury attorney Jeff Roberts. Jeff, how are you, guy?
I'm doing good, Jim. How are you?
Buddy, I'm doing fine. You know, it's funny. If I go back and listen to probably 117 of the previous episodes, I think that's how we start daggone near every one of the episodes. And I get a chuckle every time, but it's kind of a habit now.
It is a habit, so it's, and I think you're right. I think nearly every episode, if not every episode, started pretty much that way, which is fine with me. I'm kind of a creature of habit anyway. So.
There we go. So today we're going to focus on workers' compensation injuries. And this is something we haven't really jumped into before, but as we were talking, you know, there are a lot of injuries from food production here in the region, not just right here in Calloway County, but all the way across the Western Kentucky region, and probably further out. But I think today we'll kind of constrain our conversation to Western Kentucky.
True. There's a lot of food production in this area. And you know, a lot of people, when you say food production, you're thinking of farming, and obviously there's a whole lot of farming in Western Kentucky where I practice at both crops and cattle from that standpoint. But when I'm talking about food production here, I'm talking about more the manufacturing side of it, where in the plants where they're producing the product that's going out onto the shelves, so to speak, from that standpoint. And there's been a lot of food production in this area for a long time from that standpoint as well there. And, a lot of different counties that I have handled cases in that have food production facilities in those. Here in Murray, we've got a couple, Kenlake Foods, Saputo, are two that pop up in my mind frequently that we unfortunately see injuries from both of those.
And Kenlake does packaged foods, right?
Kenlake does packaged foods. It's actually part of the Kroger companies from that standpoint, and they do packaged foods for Kroger. I'm assuming, I don't know if they do it for anybody else or not. But they do packaged foods and things there.
Saputo's a dairy focused producer.
Dairy product is what they do there, and so you have both of those here locally in Calloway County. There you have a lot of chicken processing. In Western Kentucky as well, with Pilgrim's Pride over in Graves County. They've got the processing plant out at Hickory, and then some of the other facilities closer into Mayfield from that standpoint. And then Tyson has different places throughout. I think they have a place in Bowling Green, which I handle several cases out of Bowling Green as well. And then a processing facility, if I'm not mistaken, up around Madisonville area.
There's another one over near Henderson, right? Just
between Madison, Seabury, I think, is actually where
Yeah.
it's at, between Madisonville and Henderson. From there, and then in I know Christian County has some processing plants there, and if I'm not mistaken, they've got one that
It's fairly new, right?
Well, and I don't know that it's up and running now. I think it may be up, and I think full production is supposed to be in 2026. Kitchen Food Company. I don't know much about it.
It's an Australian company, I believe, right?
That's my understanding. Australian. They do premium packaged meats or something of that nature. I don't really know much about that one at this point in time, and but I know there's some other food processing places up in that area as well. So, I have throughout my career, I've handled cases, workers' compensation cases for injuries that have been in the food production business.
Well, and as we've done in previous episodes, I do kind of like to go through just a logical outline of some of the different types of injuries that you're going to get. And luckily, we've spoken about a number of these types of injuries in previous episodes. So in the show notes, I'll put links if people hear that and they want to learn a little bit more about what kind of workers' compensation claim may be related. Some of the other episodes may give them a little bit of extra context there behind it and help them prepare for, okay, what would a claim entail and kind of what what that would be. I think across the board here in food production, you're going to see lacerations and cuts. I mean, that's just kind of an everyday kind of situation, I would think.
It is
Unfortunately,
a lot,
but
unfortunately, a lot of the food production facilities, like Pilgrim's Fried, where they're cutting different parts of the chicken apart and packaging them up separately. You've got other meat processing places where they are using saws and cutting into the meat from that standpoint. So you see those type of injuries there frequently. I've had, unfortunately, some people have had some significant lacerations where they've injured nerves, etc.
Wow.
From that standpoint, all the way to amputations from the saws that they're having to use at times, finger amputations, things of that nature. That you can unfortunately occur in those industries. One thing that you need to make sure when you work in those industries is make sure all the safety equipment is on the machines that you are working with, the guards, etc., are all functioning, and if they're not, bring it to your supervisor's attention so maintenance can get that fixed. I've had, throughout my career, I've had way too many individuals who suffered injuries because safety equipment wasn't working properly. Sometimes maintenance issue, sometimes conscious decision by the employer to remove the guard or the safety equipment.
we can move a little faster, that kind of thing.
That's what they think anyway. I'm
Yep.
assuming. I'm not quite sure. But clearly they weren't. They were more concerned about production than they were the people, and that's not the way any manufacturer ought to be, in my opinion. And so, make sure that you do have that safety equipment working on your machines. And this is not just in food production, this is any type of manufacturing, frankly, from that standpoint, and bring it to their attention if not. And if you got a safety committee in that facility, bring it to the safety. If it doesn't get fixed by your supervisor, bring it to the safety committee's attention and keep hounding them until that it is fixed, because they aren't the ones, your supervisor or the plant manager aren't the ones who's going to live with the injuries. You're the one that's going to live with the injuries. The one who's working the machines is the one that's going to be injured. So.
Yeah, and unfortunately, we've done a couple of episodes already dealing with amputations and paralysis. I mean, you go back to, I believe it's episode 26 and definitely episode 13, where we'd go a little bit deeper into those types of injuries and kind of what can happen. But, when you started talking about the saws and the blades and things like that, this could happen in a deli. This could happen in a gas station that's cutting up some lunch meat. You've got to be careful. And the guards and all of that stuff, it's important. It's very important for your safety. Jeff, I believe you've already mentioned in previous episodes as well, when you get into OSHA violations, I mean, would that potentially kind of get into that neighborhood? And how does that actually affect a claim if there's an OSHA violation?
Well, if there's an OSHA violation or any type of safety violation, from that, it doesn't necessarily have to have an OSHA fine associated with it. But if there's a violation of a safety statute or regulation or safety protocol, then that can actually result in an increased benefit as a penalty, so to speak, to the employer. And the injured workers' benefits, their income benefits, both temporary total disability and permanent disability benefits, are increased by 30%.
Wow.
From there. So it's a pretty significant increase, proportionate-wise anyway.
Still not worth the injury. But,
not worth the injury. That's the reason I said proportionate-wise. From that standpoint, it's not, that's clear negligence in if it was a civil case, the recovery would generally be much greater than what you're going to get in workers' comp from that standpoint. But there is a 30% increase in the benefits to the injured worker if that occurs, if there's a safety violation. By the same token, if the employee commits a safety violation, so a maintenance worker is supposed to use lockout, tagout when they are working on these saws or whatever, and they don't do that, and then they suffer an injury because they failed to follow the safety protocols that were in place for them, then they can be penalized and their benefits be reduced. It's not quite as great as a 15% reduction against the injured worker from that standpoint, but there is a penalty that it works both ways. If the employer violates a safety statute, then they are penalized. If the employee violates a safety statute or an employer safety rule, then they can get penalized for that as well.
It doesn't mean they can't get benefits. It's just a lesser amount.
The benefits are reduced because of their violation in that situation. Yeah.
Well, and I know we've actually done an episode on that, so I'll try to link that back in the show notes as well. Thanks for that information. You just don't really think about this, but that's what makes this so complicated. Is there are always multi-layers of different issues that come in. It could dramatically increase or decrease, unfortunately.
Correct.
The life of the claim and the amount of the claim.
Exactly. Yeah.
Okay. Well, another thing that comes into when you're talking about food production, you get into the risk of burns, and this could be, it's thermal. There's a heating element involved, and obviously you touch it or you got near it or whatever. But there's also the issue of where you get scalded with steam and things like that, and that could be in a number of different manufacturing environments. But I would think particularly in food production, both of those are higher risks.
Yes. You do see those injuries. From that standpoint, the burns from hot objects, but steam coming out or other hot liquid coming out, you see that both of those types of injuries. You can get into some very serious third-degree burns, depending on the situation. A lot of times, the burns that you see in these aren't third-degree, which is good. From that, but there can be some very serious burns, and I've unfortunately represented some people who had very serious burns from both of those type of settings where hot liquid got on them. Hot oil especially is, it's really hard to do that, and that can create some real serious burns because it sticks to your skin, and trying to get it off is very difficult and very painful at times if it's already burnt very much. I don't want to get too graphic or anything in this, but yes, it can be. You can have very serious injuries from both of those. So.
Well, I know we actually did an episode on chemical burns, but we're talking about thermal and steam and heat related burns here. That and I think a lot of people think, well, hey, that was my fault. I shouldn't have gotten my hand close to that. But if you got injured and you're in the workplace, you should be qualified, I would think, under most situations, for a workers' compensation claim. Is that logical?
Correct. Yeah. If you're injured on the job, except in a few rare circumstances, if you are injured on the job, then you're going to be eligible for workers' compensation benefits. Now, if it's because of a safety violation, then you have a reduced benefit like we just talked about. But if it's an on-the-job injury, even if you were quote-unquote negligent in causing the injury yourself, you're still eligible for workers' comp benefits. Negligence doesn't really come into play in workers' compensation cases. The employer doesn't have to be negligent for you to get workers' comp. If you're negligent, it doesn't prohibit you from getting workers' comp benefits. The question is, were you injured during the course and scope of your employment? And if you were, then you're most likely going to be eligible for benefits. Now, if it's the one exception right off the bat that comes to mind is if it's because of your intoxication, voluntary intoxication, then you don't get benefits. If the injury is from voluntary intoxication, that's an absolute defense, and you're not entitled to any benefits under the Workers' Compensation Act.
And that could be alcohol or drugs, right?
Actually, right now, that's unclear in Kentucky on alcohol. There's been a recent court decision that said on the alcohol side, but they changed the statute in 2018.
We did talk about this.
I think we did. That's fine. But prior to 2018, the employer had to establish that the intoxication played a role in the injury. In 2018, they changed the law to if you were intoxicated by an illegal substance or a prescribed substance in excess of what was prescribed to you.
Doubling up on how many pills you took.
If you're taking too much of your pain medication, or if it wasn't prescribed to you. So if your wife had a pain medication there and you had a toothache and you took one of her pills and it's still in your system, It's got to be by a blood test, or by the amount in your blood. So if it's still in your system, then it's presumed that that intoxication led to the injury. I don't like the law. It didn't make sense to me when they did that because, frankly, injury or occupational disease. And so if you take a lower tab and then you're diagnosed with black lung, which is a condition you get from breathing coal dust in for years, the lower tab is presumed to have caused the black lung, which is ridiculous the way that statute's written, but that's the way it's written. And so, but it says illegal or prescribed in excess of what's prescribed to the person. And alcohol is not an illegal substance. And so there's been a recent court decision that says the way they worded this statute, while alcohol is intoxicating, it's not an illegal substance, it's not a prescribed substance, so being under the influence of alcohol at work doesn't result in a intoxication defense like it does for the other things. And so my expectation is that this upcoming legislative session, there will be there will be changes to that law to include alcohol in that. Hopefully they will go back to the system of you have to establish whatever the substance is played a factor in the injury or the occupational disease from that standpoint. And if they, I'm fine with that. If you show up intoxicated to work and get injured, that's on you, in my opinion, from that standpoint. So I'm fine if you establish it, but if there was one that a gentleman called me up to talk about to see if he could see if I could help him in bouncing ideas off of each other to find a way around it, where his guy was outside working and I can't remember what he was doing, but he's working on the line by a ditch somewhere, something to that effect anyway. And he was, he crouched down working, facing one direction. The road was behind him, and somebody was backing a truck in and cut it too short and run over this guy. Wow. This guy had marijuana in his system. I mean, there was video of, I didn't see it, but the attorney that contacted me said there's video showing it. He's sitting there working, had no idea the guy's backing up or anything else. And he gets run over, and the insurance company said he had marijuana in his bloodstream, so we don't have to pay any workers' comp benefits.
Wow.
And I think they ultimately, I never did see any appellate opinions on that issue, but at least the way the statute was written, I think I told him, I think you got a long road on this one to be successful, but I don't know if he ever was or wasn't. From that, I never did follow back up with him. He didn't follow back up with me, but that law is ridiculous. But we're getting off topic.
Yeah, sorry. Yeah. So we kind of, but how we got down this road here is we were talking about the fact that, generally, if you're injured in the workplace, for the most part, you should be able to file a claim.
Yeah.
Then we talked about maybe there might be some exclusions there,
Yeah.
some complications. Let's go over to something that has got to happen more frequently than not, and that's repetitive shoulder injuries. And I think you've actually seen some of these before.
Seen a lot of these in this field. A lot of these processing facilities, for whatever reason, when they're doing batch processing of a lot of product, and then they break it down into smaller products, but you make a large batch to start with and then bottle it into smaller or package it into smaller products. Well, with these, a lot of the companies have it set up to where employees are dumping heavy bags of product overhead into the bins that mixes everything together. And over time, that's going to result in injuries to the shoulder. If you have somebody lifting 40-pound bags over their shoulder, over their head, repetitively, hundreds of times a day, or it doesn't even have to be that often, frankly, but you do that long enough, they're going to suffer a shoulder injury. It is a given, pretty much, in that regard. And, I have represented a lot of people in my career who suffered injuries doing that. And, there was one time that I had, I'd resolve one claim, and, a little bit later, somebody come in from that same employer doing that same job that took over when the previous client had to take off for their work injury, and now they've got a shoulder injury, and like 3 or 4 in a row that had the shoulder injury doing the exact same job, and it's like, you take them, pay a little bit of attention and do something different, build it up, but either get they've got these things that you see them, trash trucks use them all the time. They take and dump the trash and then set their trash down.
Like a mechanical arm or something.
Yeah, put a mechanical arm on there where, they put the product here in this and then push the button and it flips it and dumps it in and then comes back down and they fill it up down low again instead of lifting product up over their head all the time. And it just, it doesn't make sense to me why employers don't look at these type of jobs. There's some employers, don't get me wrong, there's some employers who go in and they do ergonomic checks and they try to make the thing do it the most ergonomic way possible to cause fewer injuries. And then you got others who just, you're kind of like a piece of equipment you wear out. They pull you out, put another piece of equipment, another employee in your place, and it just you shouldn't. Well, I'm gonna get on my soapbox, and I don't need to do that.
I'm gonna go out on a limb and say it might have something to do with the cost. Yeah. It just might.
Well, it may have something to do with the cost, but the workers' comp claims and treating your employees that way costs more in the long run.
In the long run, especially if it happens to multiples. Friends, if you're interested in issues dealing with repetitive motion injuries or injuries to the shoulder, arm, and hand, check out episode 111, so it's 111, and then also episode 31 on the podcast. And you can find these back at jeffrobertslaw.com. Go over to the media tab, and you'll see a button there for a podcast. And so there's a lot of information here. And that's really one of the reasons that Jeff and I have done so many of these podcasts is to take these types of legal issues and break them down and make them really simple to understand so that everybody goes, hey, you know what? Maybe I do have a claim here. So there's a lot of great information there. Don't pass up on the chance just to kind of go out and find an episode that might be relative to the type of work you do. You might find out that there's some good information in there for you. I hate to say it that way because you're injured, but if you're trying to figure out what my options are, there's some good information.
Right.
Jeff, let's skip ahead. What we also see in these types of plants is when and this happens in all sorts of facilities where you have some kind of slip and fall or trip and fall. These things happen a lot, and especially when there's a lot of overhead stuff going on, especially when people are moving, you got forklifts running around, and you're just going to have a standard, slip or trip or fall type of injury that happens. Once again, you see it in the food processing industry.
You see it in food processing. A lot of times in other manufacturers, you will see tripping over something sticking out in the aisleway.
Leaves a bend in the aisle.
Yeah, something of that nature. In the food processing, what I see a lot is from some sort of product being on the floor. Even a powder. If it's a place that works with flour or something of that nature, powder on the floor can be very, very slick. People may not realize that, but yes, you step out onto something that's got powder on it, it can be very slick. It's part of the reason why they use that when they're rolling dough. It keeps stuff from sticking from that standpoint. And then but also in these, part of it is, there's a lot of cleaning that is required, and they need to be doing that. I want them to be doing that because I'm eating their food product. So you got a lot of water that's being used to sanitize and clean the equipment down from that standpoint, and that gets on the floor as well. And so you have people slip there, and a lot of these are using oils as well, especially the ones where they're doing the cooking and all of that in these the product in those, and when that gets on the floor or gets on people's shoes, that can cause a very slick surface to occur too and cause falls. So I see a lot of slips, and maybe not all the way to the ground. You don't have to fall all the way to the ground to injure yourself. A lot of times I see they slip and they catch themselves, but they twist a knee and then they've got, torn ligaments or something of that nature from that event occurring. So even if they don't fall all the way to the ground, you can see injuries occurring as a result of those.
Yeah, I'm thinking back to some of the plants I've been in, and obviously when there's a liquid or spray or stuff around, sometimes you see these large industrial mats on the floor, and I would think, coming on or off of those mats, again, sometimes you have a 1 inch, lip there that you got to be careful of. It's another thing to trip on.
Correct.
But that happens. And
Yeah.
when you're talking about the cleaning, there's got to be some kind of cleaning agent, whether that's a soap or some other kind of chemical that just makes the whole thing even slicker.
Correct.
And again, that's just another hazard you got to
Yeah.
worry about. And I'm sure as anybody that's working in this industry probably has a list of stories. Oh yeah, you forgot this, you forgot that, so it can go on and on and on.
Oh, yeah.
One of the things that we that might be a little iffy as far as whether or not it actually, would result in a workplace injury claim, a workers' compensation claim. We talked a little bit about foodborne pathogens. Do you want to kind of talk about why that might be a gray area? But I would think in the chicken processing, the poultry processing in particular, that might be an issue.
Well, it's not, the gray area. It's not really as much of a gray area. I mean, it can be in regard to establishing where you contracted.
Yeah.
From that. So yeah, did you contract it from working at the facility, or did you contract it because you went out to a restaurant that did not fully cook the chicken, or whatever product it is, and then you've got the foodborne illness from that standpoint. And so that's where salmonella, other things that come in from that perspective, and establishing causation can be difficult if you have a facility where you have 4, 5, 6 people that come down with it around the exact same time, and they live distances apart from each other. Then it's a little easier to establish.
Must be acute enough that you can say, something's
Correct.
going on here.
Yeah, but most of the time, those issues are also, thankfully, short-term and full recovery from that. So you have a few or several days that are not very pleasant, but usually you make a full recovery, don't have any long-term consequences. Usually, I'm not going to say it never happens. But if you're out for 3 or 4 days, you come back. Unfortunately, the way the workers' comp law is, to get paid workers' comp benefits for being off work, you have to be off work 7 days. So you've not been off long enough to get a workers' comp check for the time period that you were off. So you got to use your sick days or just not get paid or whatever in that situation. And most of the time, it's go to your family doctor. He gives you medication. And medical bills aren't that great, and thankfully there's not permanent issues. So those don't generally turn into a workers' compensation claim, just because there's no permanent aspect of it in the length of time that you're out, and then the medical treatment is fairly low, so it just really doesn't generate a claim.
Well, I know if you've ever had food poisoning, you're praying that doesn't go 7 days. I mean, that is a
Yes.
miserable condition.
Yes.
And you hope, after a day or two, everything starts to settle back down and you get back to normal life. But yeah,
Right.
that's miserable. I would hate to say, yeah.
Luckily, I've never had it.
I've had it.
Now,
I've had it a couple times,
because
yeah.
you brought it up, you jinxed me. I'm going to have it before the end of the year.
Choose your restaurants carefully.
Yeah.
If you've got teenagers at home, tell them to put it back in the refrigerator. You don't want them to, cause something for you as well. It's always always fun. But Jeff, let's talk about this. If you've, as we start to wrap up here, if you have sustained an injury, one of the first things you have to do, and we've talked about this in so many episodes, you got to notify your employer. People skip that step, and that can have a bad effect on your claim.
It can, it can be the end of the claim. The law says you have to give due and timely notice of the injury, and if you don't do that, then the claim is no longer a compensable claim. And so you need to notify the employer.
And that could be a supervisor, that can be somebody in HR, that could be somebody up the ladder.
Most of the plant policies are, you notify your immediate supervisor. If there's plant medical, you go plant medical, notify them. Type situation is kind of what occurs most of the time there. But plant policy does not dictate Kentucky law. So if the plant policy is you got to go up to HR and report the injury to HR, and you didn't do that, but you did tell your supervisor on the floor that you suffered this on-the-job injury, you've complied with Kentucky law, in my opinion.
You may also see you got to report the injury within 24 to 48 hours, and that's not necessarily.
That's not the law either.
Yeah.
You have a reasonable time frame within which to report the injury from that standpoint, but report the injury as soon as you know you've suffered a work-related injury. And then, so yes, you need to take that. That's the very first step. Report the injury as soon as you know. The other step is also when you go to the doctors, let them know that this is from a work-related injury, because if you told your supervisor and the supervisor didn't do their job of going on up, but you went to the emergency room that night and said this happened at work today, and this is what happened, that helps. Now we still may have a notice issue, but we can establish it occurred at work, and then the notice issue is not, and then you start missing work, they're going to, that notice issue gets less and less and less from that standpoint.
So be proactive.
Be proactive.
Yeah.
And I have, unfortunately, I've had to tell clients or potential clients, I can't, if you didn't notify them and it's been a year since the injury and you've never notified them of this injury, the odds are we're not going to be successful, so I can't get involved in your case. And so that occurs at times.
Well, Jeff, as we wrap this up today, we've talked about Kenlake Foods, we've talked about Saputo and Pilgrim's Pride and the various Tyson facilities, and also the new facility, Kitchen Food Company. That goes to say you've got a regional practice. I mean, because you're based in Calloway County here in Murray, but you've also got another office over in Hopkinsville in Christian County. But you actually have a regional, and from time to time, you're doing claims all across the state, right?
That's absolutely correct. I handle cases in Western Kentucky, but I also handle them all over the state. I've handled cases. I have cases going now where my clients are in Louisville, Bowling Green. I have several clients in Bowling Green, several clients in the Louisville area, but I've literally represented clients from Paducah to Pikeville and from Murray all the way up to Covington, Kentucky. So I have spanned Kentucky from that standpoint, and really with the more prevalent use of video conferencing has made it a little easier from that standpoint. DocuSign and things of that nature makes it much easier to represent clients that are further away.
And that's just being able to sign electronically on a form that maybe got emailed to you or something like that,
exactly.
Right?
And that's I'm still a big fan of face-to-face communication, which I can engage in here in the office, but I can also engage in the video conference, and I can see facial expressions, and I can tell if I'm, I try to explain things to my client in everyday language that they can understand, because telling someone something in a way that they can't understand it doesn't accomplish anything. You might as well not tell them from that standpoint. I want my clients to understand what's going on, understand what is going to occur in the future from that standpoint. And so I try to educate my clients in that way, but in a way that they can understand as well. And if I'm talking to somebody where I can see them, I can tell if they're not. Sometimes people don't want to admit they don't understand.
Right.
And so, but I can see I'm losing people at times, like I see when I'm talking to you occasionally.
There you have it.
But I can see I'm losing people at times, and then I know to go
Yeah.
back and cover it again, go back and cover it a little more thoroughly for them. And I like that because I want my clients to know what's going on. As you know, I have an office motto, and it's to provide small town service, deliver big city result. One of the parts of providing small town service is keeping my clients informed and keeping them informed in a way that they truly understand what's going on, answer all the questions that they have, but answering it in a way that I'm not using legal speak. I'm talking in everyday language to them so that they understand that, I can use $100 words if I need to, but I try not to. And frankly, most of the time, people who do that are just doing that so you think something about them as opposed to because they're wanting to convey information to you. And when I'm talking to my clients, I want to convey the information to them so that they can make informed decisions. It's their case, not my case. I will tell them what I recommend that they do, but I'll give them all the information so that they can make an informed decision.
That makes a lot of sense. So, Jeff, if I'm listening to this and I want to get in touch with you, regardless of whether I'm out in Pikeville or up in northern Kentucky or over in Jefferson County, Louisville area, or right here in western Kentucky, even though you've got the two offices, you've got one phone number.
I got one phone number. It's 270-753-0053 is the phone number for my office. I do have an 800 number for people out of the area. I don't know with the use of cell phones now, I don't think long-distance chargers are as big of an issue as they once were, but I've kept that 800 number. It's 1-800-844-5108 if you want to use that. I actually need to go back and look at my phone bill to see if anybody is using that anymore. But you can use either one of those to reach me. That is the best way to reach me is through the phone from that standpoint. And then, you call in, we will get some information from me and see if I can help you out.
Outstanding. Jeff, thanks for your time. It's been great talking to you about this. And this is one of those industries that, everybody seems to think about, okay, we're going to go talk about construction or we're going to go talk about automotive. But food processing is a very predominant industry or industry sector here throughout Kentucky. So I'm glad we took the time to do this today.
Yes. Thank you.
All right. Take care. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.